Lately in our office, we have been getting a lot of questions and inquiries about land contracts. Ohio actually ranks number 2 among all of the states for land contract usage. I'm going to start out with a general disclaimer. If you are buying property or selling property and you can avoid doing it, avoid it. But if it can't be avoided, or if you are a property owner who has already entered into a land contract, it's important to have an understanding of the laws that apply. A land contract is a type of real estate transaction where the buyer, who is often called the vendee, and the seller, also referred to as the vendor, enter into a written agreement where the buyer is going to make monthly installment payments for a specified period of time. And then once the contract is paid off, at that point, title will transfer. It's ideal for buyers who don't qualify for traditional mortgages or other financing. It can offer some flexibility, but there are a lot of loopholes that you need to be aware of. In Ohio, land contracts are governed by Chapter 5313 of the Ohio Revised Code. And one important thing to know is Chapter 5313.02 lists about 16 to 20 specific things that need to be in a land contract or other specific requirements. It also must be recorded in the county where the property is located in order for the land contract to be valid. It is really important to work with legal counsel if you are entering into a land contract, either as a buyer or a seller, to make sure that it complies with state law. If a buyer defaults under a land contract, Ohio Revised Code also sets forth very specific requirements that need to be met. The buyer has 30 days to cure a default. The seller may have to either evict the buyer in the municipal court if the land contract has been in place for less than 5 years or less than 20% of the balance has been paid. If the land contract has been in place for more than 5 years, or if the buyer has paid 20% or more of the purchase price, then the seller must file a foreclosure action in the common pleas court in the county where the property is located. For our community association clients, I'm often asked whether a land contract violates a leasing restriction. Because it is a contract for purchase of the property, for those associations that have leasing restrictions in their governing documents, as long as that land contract complies with Ohio Revised Code 5313, then it is not a violation of a leasing restriction. Also, the voting rights and the obligation to pay assessments and the right to serve on the board all remain with the seller until title transfers. So why is legal counsel crucial when we're talking about land contracts? Improper land contracts can be invalid or unenforceable, and legal guidance ensures compliance with Ohio law, protection in case of default, and proper handling in the homeowners association or condominium context. Thinking of buying or selling by a land contract? In a land contract and facing issues? Contact our office to protect your investment and ensure compliance.